Hi, this is Mike Regan with TranzAct's 2-minute warning for the week of May 18th. In this week's 2-minute warning, we have an important update on the recent Supreme Court decision involving C.H. Robinson. Last week, the Supreme Court issued shockwaves that went throughout the transportation industry when they ruled 9-0 that C.H. Robinson could in fact be held liable for an accident caused by one of the carriers they had chosen to move freight for one of their customers. Now, I want to emphasize, the court didn't find C.H. Robinson guilty. It simply said that the case that C.H. Robinson brought to them, saying that they couldn't be sued because of the federal preemption laws under the Federal Aviation Act, the Supreme Court said, no, you can in fact be sued in state courts, and that looks like what will likely happen. Now, the reason this sent shockwaves through the industry is it exposes a couple of key issues. First, there is no federal standard that basically says this is a good carrier to use. Now, I've been involved with TIA, Knit League, and other organizations, and we have been agitating for this for like a long time. We would love to see it included in federal highway legislation, but that has not yet occurred. But the key issue also is when you take this out of the federal area and put it into state courts, well, folks, you're opening up Pandora's box, jury shopping and everything else like that. And when you take a look at what's happening with judgments in cases involving truck accidents, it's positively scary. You've got the issue of nuclear judgments and all sorts of litigation fees. And that's why it is so important, not just for brokers, but for shippers to also make sure they have a clear, written, documented policy about how they choose carriers to haul their freight. Now, a couple years ago, TranzAct was all over this, and we brought to the attention the things like the CSA program under the federal FMCSA's group. The DOT has also said they're going after unsafe carriers. A lot of attention's being paid to this. So if you think you're going to get out of it by saying, well, we're going to hire a broker to select the carrier and let the liability ride with the broker, folks, what kind of vetting are you doing for the brokers? Now, if you're interested in learning more about how you can protect your company's interest and make sure that you've got some kind of selection process that can stand up in court, give me a call. We're working with somebody that's really great in that area. Be happy to share the contact information. But more importantly, we also can share information about how you can protect your supply chain on some other critical issues that are going on. Now, if you're interested in learning more about how TranzAct can help you on this whole carrier vetting process, send me an email, give me a call, or let's get together in Calendly with a one-on-one discussion. Won't cost you a dime, could potentially save you a lot of money. And we make all of this available because with each and every 2-minute warning, we're here to remind you, we are on your team, here to help, passionate about seeing you be successful. Thanks for your time.